Whether you're an employer or an employee, the best advice is to seek legal advice at an early stage in any dispute or workplace situation. This should be done as early as possible to seek advice on tactics and also to clarify what claims may exist. If you are an employee and you decide that you need to bring a claim and this follows a dispute at work, perhaps after you've followed the various policies, such as a bullying policy or a harassment at work policy, or maybe even a grievance policy, then you will need to follow a strict time limit in which to enter your claim. Usually this is 3 months. So if you are an employee and the last act that you're complaining about, or your dismissal was nearly 3 months ago, then you really must act immediately, or you'll lose the chance to bring a claim in the Employment Tribunal. Sometimes an employee's workplace situation becomes untenable or unbearable, and they feel the need to simply leave the employment on a very short time span. This is sometimes known as constructive unfair dismissal and will follow an event such as blowing the whistle or a discriminatory act which they complain about, or maybe they don't even have time to complain about before walking out. And this would be, for example, on the grounds of race, sex, disability, sexual orientation, age, or maternity or pregnancy. These are known as constructive unfair dismissals, and they should only be undertaken with legal advice wherever possible. Before entering a claim in the Employment Tribunal, it is now obligatory for an employee to enter into a process known as Early Conciliation through ACAS. The ACAS is an independent body which can be contacted via an online form or on the telephone. And the purpose of Early Conciliation is to seek a resolution between the employee and the employer, and the ACAS conciliator would try and do that. The resolution may be an apology, or it may be a settlement sum, or some other form of agreement which the two parties enter into. It is only when the conciliation period ends that an employee can enter an Employment Tribunal claim, and they must be able to enter on the claim form the conciliation certificate number. If a claimant doesn't enter into early conciliation, the claim will be rejected. Once an employee enters a claim, ACAS can continue to conciliate, but the early conciliation period will have ended. At some stage, the employee will decide whether or not they wish to enter a claim. This is done by way of an ET1, a claim form, which is found on the Gov website, and it can either be done online or printed off and sent to the tribunal. It's an easy form which largely consists of tick boxes, but there is a section in which the claimant must enter the details of what the claim is about, and this is done in everyday language, explaining chronologically how and why this claim has occurred. The claim has to exist in law, and so for that reason it is advisable to seek some advice in relation to whether or not the claim is covered by law. There are strict time limits to bringing a claim, as I've mentioned earlier. It is usually 3 months from the last act complained of or the date of dismissal. If there's any doubt about the limitation date, then you should seek advice from a lawyer or from ACAS. But if you miss that 3-month deadline, the chances are that you will not be able to bring your claim and you will lose the opportunity to do so. If you are an employee who has been dismissed, you should try and appeal the dismissal internally before bringing a claim. It's important to realise, however, that appealing doesn't change the date of your dismissal, nor does it extend the time in which you can bring a claim. The date of the dismissal will remain the same. If you appeal, you should make sure that you still keep an eye on the limitation date for bringing a claim. and for that reason you should not delay putting in a claim pending an appeal. If you bring a claim, you should also remember that that will not change the dismissal, because the dismissal will stand, as will the reason for the dismissal. The only way of reversing a dismissal, for example, for gross misconduct, will be to go through an internal appeal. Once you've had your notice of acknowledgement from the tribunal and you're awaiting the case hearing, what you will find is that it is listed usually between 3 months from the date of the response going in to 9 months. And this will depend on the availability of your witnesses, judicial resource, and how long the case is. The longer the case, generally speaking, the longer you'll have to wait until it's heard. The vast majority of claims that are brought in the Employment Tribunal are brought for unfair dismissal. Only employees can bring claims for unfair dismissal, and usually they will have served at least 2 years in their employment. Self-employed contractors and workers, casual workers or zero-hour workers, can't bring unfair dismissal claims. An employee is somebody who works under a contract of employment, and that's a short form of the legal definition. To bring a claim of unfair dismissal, you will have been dismissed for a reason that's not a fair reason, and there are only 5 fair reasons, and those are redundancy, conduct, capability, illegality, or some other substantial reason. If your reason for dismissal is not one of those reasons, then it is likely to have been unfair. It is essential for an employer to have followed a fair procedure, carried out a reasonable investigation, and acted reasonably in dismissing that employee. And those are tests that are brought in the Employment Tribunal. So if a matter gets before an Employment Tribunal for a hearing, the Tribunal will decide on an unfair dismissal, or indeed any dismissal, or a claim that's brought for example, discrimination where the employee remains in employment, on the basis of fairness. In dismissal cases, the Tribunal will take into account whether in all the circumstances the employer has acted fairly. In these cases, the Tribunal will even look at the size of the company and the administrative resources of it when it's been acting in a dispute or in a dismissal procedure. The ACAS Code of Conduct will be taken into account by the Tribunal, but it is not a lawful diktat to a tribunal. It will simply be guidance that will be considered by the Tribunal. As I've said before, tribunals will look carefully at how long an employee has been in service, and for unfair dismissal cases, an employee must have 2 years or more. In dismissal cases where there have been discriminatory reasons, or an employee has been dismissed for blowing the whistle, there is no service requirement. An employee can bring a claim after a few hours. Indeed, for discrimination, even applicants for roles can bring claims in the Employment Tribunal. In other words, they will not have been an employee at all. When an employer resists a claim in the Employment Tribunal, it will be very wary of the fact that an Employment Tribunal can order re-engagement of an employee. But ultimately, an employer doesn't have to take an employee back and can pay compensation instead. So I've mentioned the fact that claims can be brought in an employment tribunal by people who aren't employees. So these can be self-employed contractors or workers who are either casual workers or 0 hours workers. It amounts to the same thing. And they can bring claims for detriments under the following regulations: the National Minimum Wages Regulations, rights under the Working Time Regulations 1996, making of a protected disclosure, which is sometimes known as whistleblowing, which is under the Public Interest Disclosure Act of 1998, and also rights under the Part-Time Workers. This is the Prevention of Less Favourable Treatment Regulations 2000. Whether you are an employee, a worker or a self-employed contractor, you can bring claims for discrimination under the Equality Act 2010 if your contract is terminated by an employer or by an organisation for a discriminatory reason, or if you're treated unfairly for a discriminatory reason. Solicitors need to be brought in if possible, or you need to seek advice in some way on tactics and whether or not your claim is covered by the law. Qualified lawyers are needed to review the following: contract documentation, looking over claims for unfair dismissal or discrimination, compromise and severance agreements, looking at disciplinary procedures, ensuring that redundancy and dismissal procedures are fair, and any allegations into discrimination on the grounds of a protected characteristic such as race, sex, disability or age, and sexual orientation. Thank you for watching this short video about how you can bring an employment tribunal claim and in terms of employers, how you can resist an employment tribunal claim. In both cases, it is important to seek legal advice as the process has become much more legal than it used to be. If you need more help or information, please do get in touch.